Rob Walsh, because in some respects, the institution that you presided over or counseled was in some respect the legacy of the Magna Carta in terms of the fact that Parliament was supposed to be, if you like, the restraint on absolute power. And given the fact that there is now a live discussion, is going on right now, today actually, in terms of what on earth are we going to do with Dean Del Mastro? I don't know whether any of you have been here listening to that. There is a real tension between, does the law in its full panoply apply to Parliament? And if it doesn't, what is the relationship between Parliament and the rule of law?
5 minutes, you say? As you mentioned earlier, Earl, I practiced law for a number of years, and like any lawyer, you're accustomed to working in a context of rules and formalisms with a well-defined outcome. I was in civil litigation, so you know when you go to a court, the judge will hear the case and make a decision, and you've got an outcome. And as we used to say, justice, if justice prevails, I'll appeal. But bottom line is, you have rules you can count on. But then I came into the parliamentary world, and yes, there's a book of rules, but I don't know how much you can rely on them because, of course, the members and the parties can decide what they're going to do from time to time as they see fit. But for me as a lawyer, the biggest encounter was the conflict or the interface between law and politics. And what I had to learn was something I never heard of before, although I was almost 20 years a lawyer at that point, and that is the law of parliamentary privilege. I was new to the domain of parliamentary law, and I learned about the law of parliamentary privilege. And without going into all of that in detail, let me just say that it is an area of law that I wish more lawyers were knowledgeable about. But it is, as Erskine May, the sort of locus classicus of parliamentary law, said in his book that first came out in 1844, a kind of exemption from the application of a general law. Now, you might first think, well, rule of law certainly can't mean that there's some exemption from the application of the law. Well, there is. And it's not unique to the Parliament. I mean, you have parliamentary privilege, you have crown privilege, you have various other privileges, and in due course, when you become a lawyer, you'll be very grateful to know that you probably won't be called for jury duty because you're a lawyer. So you're lucky. You won't have to sit on a jury. There are various exceptions or exemptions or qualifications to the law which can take categories of people out of the application of the law. So I just want to emphasize that to try and do some sensitivity to the notion of the rule of law as being something other than the rule of laws, because that's what I came up against in Parliament. What happened was the committee of the House, typically exercising on behalf of the House's function of holding the government to account, wanted information from the government as it's entitled to receive. And often is the case, the government doesn't want to give that information to the committee. And one of the responses of a legal nature by the department, and at times pleading they had been so advised by the Department of Justice, was that they couldn't provide that information to the committee because to do so would be in violation of the Privacy Act, that the information in question was prohibited from disclosure by virtue of the Privacy Act. It got tiresome after a while saying the same thing over and over again. I then would be brought in to say the Privacy Act does not apply to the House or its committees, except in such manner as the House or its committees might choose to cause it to apply, okay? You don't invoke a statute so as to frustrate or deny to the House or its committees their constitutional function. And the function here was to hold the government to account. Now, in the 7 years of minority government, from 2004 to 2011, more between 2006 and 2011, but certainly by virtue of a minority parliament, you had committees where the majority were opposition members. And so committees could be more muscular, as it were, in discharging the function of holding the government to account. Since the return of majority government, some of you may have noticed, there isn't much happening in committees because the prevailing majority, which is on the government side, has control of committees, and those kinds of things won't happen. But be that as it may, that's the parliamentary system. But I encountered lawyers from the Department of Justice typically, but it was a few occasions when it wasn't a Department of Justice lawyer, who would privately to me to be saying, how can a committee be doing this? How can a committee be doing that? This is lawlessness. I mean, don't we have rule of law? Of course we have rule of law. but I had to stop and think, what is that? Rule of law. I vaguely recall what it was. But rule of law is not the rule of laws. The rule of law has a number of dimensions to it. Of course, the rule of law includes having an independent judiciary, of course. But then the issues, the actions of a House or its committees is not subject to judicial review. So in a sense, this is an area of law, but as courts have said as far back as 1704, parliamentary privilege is part of the law of the land. It is part of our system of laws. And even though it offers latitude to the House, and in particular its committees, to operate in disregard of laws that might otherwise apply, nonetheless, that's part of our system of laws. And yes, as the Supreme Court of Canada in Vade affirmed in 2005, the House has the ability to be both judge and jury about the application of a law to itself. And it can choose to disregard some laws in regard to its proceedings, if that's what it wishes to do. And in my view, and this is the point I really want to make, and it's almost a political message or a political science message, I suppose, is that we need to have parliamentary privilege and its various tenets so that our democracy can play itself out between elections. Now, we are, as the court has said, a constitutional democracy. We are governed by the law, of course we are. And the rule of law is important. Matter of fact, the Constitution puts it right up there with God. You read the recital to the Constitution Act 1982? What is it? The respect for God? Supremacy of God and the rule of law. Well, in some parts of this world, as we're now hearing much about, the supremacy of God seems to have priority over the rule of law. But then again, God's law is the rule of law, I suppose. But fortunately here, we put the rule of law in a high regard, as we must, okay? I'm not sure what supremacy of God means in that context, but I'll leave that alone, unless there's a theologian in the room. But rule of law is important so that we can all have confidence in our system. But the parliamentary privilege is an area of law which is outside that, so that our democratic politics can play itself out fully. And the one privilege I'm sure you've all heard about is the freedom of speech in the House. Now, normally, if someone says something nasty about someone else, that other person will probably have the right to sue in court and recover damages by order of the court in compensation for the injury or damages done by the nasty statement. No, that can happen in the House. You could find yourself being spoken of very unkindly, and there isn't anything you can do about it. Yeah, that may seem unjust. Where's the rule of law on that? Because the rule of law and our system of laws has recognized that there needs to be a free and open debate in the House of Commons. And so also in a more specific case coming up soon, next spring it might happen, I don't know if it will, but it could conceivably, in the trial of Senator Duffy. Now this is where the law and politics can come right face to face. It could be that the accused wants to call the Prime Minister as a witness. Well, law of parliamentary privilege would say that members of Parliament are not liable to being subpoenaed to a court during a session of Parliament. Now, the member of Parliament in this case happens to be the member from Calgary Southwest, who currently, although he may not then, who currently holds the post of Prime Minister. Of course, there may be political considerations coming into his decision about whether he's available to the court. But it also has the implications, in my view, that if the accused does not have the benefit of testimony from that witness, whether he can't argue that he's being denied a fair trial. And so the charges against him would have to be dropped. I don't know. I mean, obviously there's a lot of detail, the devil in the details, and one would have to look at the particular issues in respect of which the Prime Minister's testimony was sought. But the point is, there's an interface there. I'm not so sure, frankly, that parliamentary privilege will apply in that case, because generally speaking, parliamentary privilege is no protection against criminal law. It doesn't apply in criminal cases, which is to say that a member of Parliament could be charged with a criminal offence and would have to face those charges, and he can't plead parliamentary privilege to in any way avoid those charges or avoid a trial on those charges. But a person being called as a witness, the courts made it very clear, including the Ontario Court of Appeal here, that a member of Parliament cannot be subpoenaed to court as a witness. And now, does that include being subpoenaed as a witness in a criminal case? I'm not sure. But in any event, the interface in law and politics is a very important interface, and we have tonight with us, and maybe we'll hear more from Mr. Cotler, as a very distinguished member of Parliament and a very experienced member of Parliament, and of course a very experienced and knowledgeable lawyer in his own right. So this interface in law and politics, I personally found to be a very, very tricky interface to where does the law let up and where does politics rightly take over, and what is the interface between the two, given such concepts as the rule of law right up there with God in our constitutional system.
Thank you, Rob. Again, from your answers, you've basically said that the rule of law has to fit in to the parliamentary framework of parliamentary privilege and responsible government. Something which I want you to think about in our second round is that does responsible government exist in Canada anymore with the power of the executive so huge, and the abuses that a strong executive, especially a majority government, can have in terms of undermining responsible government, from omnibus bills to closure to abuse of confidence motions, and ultimately even prorogation, as many people have said. Are we moving actually back to something similar to how the Magna Carta started? L'état, c'est moi. And is that something which we have to start worrying about in the second round? So maybe you can think about that when we get there. Rob, I'm afraid to actually ask you whether you think we are now in a state of l'état, c'est moi. Feel free to disabuse that allegation.
Well, you talk about whether we're back to the time of King John. When those prorogations happened, I was thinking we were back to the time of King Charles I. I didn't have to go back to King John. For those of you who might not be familiar with English history, King Charles is fascinating how he would have trouble with Parliament and he'd just dissolve it. You know, like, poof, you're gone. You're going to give me the money? Fine, shut you down. And when the prorogations came along toward the end of 2008 and then 9, I guess it was, you know, I just had this sense that, well, here's King Charles. He's just, I don't like what you're doing to me, so I'm going to shut you down. You know what I mean? Well, he didn't dissolve, just prorogued it. But the prorogations in those instances, in my view, are a reflection upon the Prime Minister as opposed to the power itself. But here's an area of prerogative powers which is, in a sense, outside the rule of law, but part of our system of laws. These powers always were with the Crown. Even you go back to King John and all the terms they made with him, there wasn't one in there saying you won't prorogue or dissolve Parliament without our consent. That came up many years later. There was a time in the 17th century when the parliamentarians wanted that to be the rule, that there would be no dissolution without their approval. And arguably a good case can be made now that that should be introduced in some manner. But in this case here, the key that's enabling this to happen is outside the law, the rule of law, and that is the politics of party discipline. And so for so long as the Prime Minister has the support of the majority in the House, he can do these things with impunity, you might say, because he enjoys the support of the House. We haven't lost responsible government. Responsible government, you may recall, is simply that which says the government is accountable to the House. And in particular, when it first came in 1848, the Governor General will not exercise his powers except on the advice of the ministry, which in turn is responsible to the elected Legislative Assembly. We still have that, but the problem we have today is that we don't have in the ranks of the governing party members who will hold the government to account outside of caucus. They may do some of this inside of caucus. That's a moot point. Who knows? But outside of caucus, we don't see anything in the way of a restraint upon the government by the members of the Prime Minister's political party. And frankly, it's not that one should expect to see that very often. It is in exceptional circumstances that it happens. It's happened in Australia, it's happened in Britain when the Margaret Thatcher's years, and it looks like it may be happening now in Manitoba in some respects, but that's what the minister is, not so much the caucus. But we have responsible government. The machinery and the setup is there. It's just that the players are not, particularly the players on the government side, are not as loyal, you might say, to the principles of responsible government and their role in representing their constituents and representing the people, as perhaps they should be. But that's a political debate. But yes, are we back to the days of King John? Well, King John and King Charles I, and who knows with the way these prerogative powers vis-a-vis Parliament have been exercised.
Thank you.